Good morning, good afternoon, good evening, wherever you are around the world. This is Dr. Nelson Ogunshakin, the CEO of FIDIC. You are welcome to this particular webinar. The topic is very simple: to dispute or not to dispute. That is the big question. Some of you may be following in over the last 1 year on our series of webinar. I'm delighted to welcome you to this particular another in the series of FIDIC COVID webinar. Exciting topic, which I think should reflect quite a number of concerns around the world. I'm informed that there is quite a lot of people that register, from 1,200 people were registered, 128 countries. I'm informed that, the highest registration come from UK with 95, United Arab Emirates with 75, United States with 73, and the list goes on. And I'm really delighted to have your, wherever you are, I hope you are keeping safe. The COVID-19, is it 19 or is it COVID-20 or is it 21? We haven't come out of it yet, but I think it's fair to say since we started the program last year, we've now run 26 webinars. We had over 20,000 that's actually registered to come to this webinar. We have 11,500 attended the webinar so far, and we are keeping track record. So far, 150 countries. And we believe we've had over 19,000 people who have subsequently watched the YouTube to see where, and what is being said. Today's topic is about dispute or no dispute, but I thought I should stop for a minute and just pause and look at the key message that's come from the industry over the last 12 months. One is that there is a new normal and the working practice will not go back to be what it used to be. Two, that the economic impact of COVID-19 will far outweigh, than the last economic crisis where we're looking at about 1 to 2 trillion impact on industry all over the world. There's concern that staff and their well-being is key to survival of any consultants and engineering or contracting firm. This is critical. There will be implication for contract, and I stop for a minute. There will be implication for contract and projects getting delayed, postponed, and potential litigation or issue that will come out of that. One of the other points that was being mentioned as well is that communication is key, either internally or externally, or even in resolving relationship within client, and the issue of dispute or no dispute come into that. Investment profile will change, and whether we like it or not, the financing, the government, the priority will change. We can see a lot of them are moving from capital projects into OPEX. A lot of them are moving into major infrastructure, into what I call, social infrastructure. Then we see the time in infrastructure in terms of the short term and the medium to long term will change because priority will change. One of the key points that was mentioned again and again is that collaboration and working together as an industry is more important than ever. And then finally, there's the comment that no company, big or small, is immune to technological change that is now going to occur in our new world. We are now speaking to you on this channel. We've been doing it for quite a while now. This year, we got 3-in-1 program. There is the FIDIC, committee, webinar series, which we've been running. The last one was really to do with issue about bribery and corruption. We had quite a lot of people who attended that. There's the, state of the world report. We've got another one due on Thursday. We've done one on infrastructure. There's one coming up on water and the case for water. And that is coming up on Thursday. And there's this series of, COVID webinar conference, which is coming through. So on that note, I'm actually keen to take you hand you over to our president, Bill Howard, who has been so kind, have not missed any webinars so far. All 26 of them, he's been in there. And I don't know how he does it. Bill, the floor is yours. Thank you.
Well, thank you, Nelson. And I'd like to first of all, thank you and the Secretariat for all of your hard work in preparing and conducting these webinars. As you indicated, they've been quite successful. And one of the benefits to FIDIC is we've been able to reach out to over 20,000 stakeholders in the construction and the engineering professions, and stakeholders are related to it. So that's been a major positive development in these very difficult and somewhat miserable times we've been experiencing with the pandemic. And the reason that we've been able to reach out to so many people is the quality of our speakers and presenters and the subject matter presented at the webinars. So I also want to thank very much our 4 speakers today for helping us continue in that vein. The subject matter today, to dispute or not dispute, is certainly uh, very critical. It's critical all of the time. I would suggest that it's probably even more critical in the post-pandemic world, where claims of delays and supply interruptions and project interruptions and that sort of thing are more prevalent. One of the themes that we have heard particularly when we get into the use of FIDIC contracts and terms and conditions and that sort of thing, is for all of us to look at that word of collaboration and really think hard about it, about how we can collaborate, which means to me seeking win-wins kind of solutions and fair and balanced kind of activities. And all of those things, I know they're easy to say, but they're very difficult sometimes to put into place because we have contracts, we have terms. Many of these are with public agencies that have their own rules and regulations, and it's not really the easiest thing in the world to do. But I would suggest that the best outcomes of answering questions of to dispute and not dispute will take place if we at least put some thought into fairness and win-win and what's best for everyone via a collaborative approach. So I'm very much looking forward to the remarks today, and I'll turn it back to you, Nelson.
Thank you very much, Bill, for those words of wisdom. I think fairness, I hear, win-win, and collaboration. That's the three messages that Bill's giving us to start off with. Let me just start by saying that the global pandemic continued to give us a crisis and challenge in the industry. Many projects and many companies, and we've seen a lot of people losing their job. But when it comes to projects, some projects have been mothballed, some projects are continuing in their form or shape, and some of the projects are going in different form whereby you really don't know what sort of issues have been coming in place. We do know for sure that, through what we did last year, there was a big concern about force majeure. How do you react to the situation? What are the legal clauses in the contract that protect you, either you as the client or the contractor or the supply chain? And what are the litigation or legal framework that is being put in place by government that change the working environment? And in either way, people are looking for solutions. Well, today's conversation is really about dispute or not dispute. How do you resolve that? What we want to do is really go through the process and actually help to identify how best should we deal with this issue. But before we go through that, there is a poll. And the poll is very simple, is that in your experience, what do you believe the change in dispute has been as a result of COVID? Is it significantly reduced? Has it reduced, stable, increased, or significantly increased? I mean, it'd be interesting to actually hear people's view. I've already voted. I hope those who are actually following us are able to vote to give us a really kickstart as to what is the perception in the marketplace as to whether we've seen an increase in the dispute. Has it increased or not? Barbara, are we in a position to give the results for that, or are we still waiting? I hear the word that it has increased. We got 53% of people said it's increased, and 24 actually just significantly increased. Well, that doesn't surprise me in the sense that we anticipated what I call the COVID has created a situation which is not really sustainable, and people really need to know how to deal with the matter. So we're going to go through our panelists. I'm really delighted to have four top-notch panelists, as Bill said. We have Lindy Patterson, we have Mohamed Ali Janah, we have Rebecca Shoza, and James Perry. What I intend to do over the next 1 hour is to put few questions to the panelists in the order that is shown on the screen. And once I put those questions, then there will be opportunity for the participant to put questions to them. And so we want to spend the next 1 hour on sort of, exchange of conversation with the panelists. And in an hour's time, we pick up questions from the participant and we throw it across on the floor. So starting on my left-hand side with Lindy Patterson. Lindy, would you care to sort of do a quick introduction of who you are? And then I've got 2 or 3 questions to start off with you. Lindy.
Thank you. Good morning, good afternoon, good evening, everyone. It's a privilege to be here today and to share everyone's views. I am a QC and full-time arbitrator, adjudicator and dispute board member with 39 Essex chambers in London. I work internationally. Most of my work, in fact, all of it over the last while has, of course, been done remotely, as has been the case with almost everyone, and it has posed its own challenges, some of which we will discuss today. Thank you.
Thank you very much, Lindsay, for that quick introduction. I'm always delighted to have you on board, and thank you for your support to FIDIC in all different angles. The question that I'm going to throw across to you, it really goes across the question I ask, is despite all the issues that we had under COVID, do you think, the level of dispute has risen over the last 12 months? And if so, in what actually, has been the highest area of dispute that you've seen or experienced from your working over the last 12 months? Lindy, the floor is yours.
Thank you, Nelson. Well, I thought the survey was very interesting because the statistics are that 77% of those who participated think that the number of disputes have increased, 53 saying they have increased 53% and 24% significantly, which really bears out my view. Of course, these things are all individual opinions, but I guess as that is what I do day in, day out, my very clear sense has been that disputes have increased. What I think is interesting, though, Nelson, and you touched on it in your introduction, is that it has probably not been in the areas or the types of disputes that we anticipated at the very beginning of the pandemic and really the global shutdown. Then there was a huge focus on force majeure. What did force majeure mean in the contracts? Everyone wanted to be properly informed. And I think most of us anticipated that claims would come from force majeure. Now, there have been some, but actually I think the disputes have arisen because of the more practical effects of the pandemic. I have been involved in many where sites were abandoned quite quickly following the shutdown, and some of them have not yet reopened. Site representatives left the sites, went back to their own countries, and then were criticised potentially later for not attending to sites. So we've seen quite a rise in termination. Contractors themselves have terminated on many an occasion because they see the lack of viability of the ongoing project, and often have seen that perhaps the employer is not going to be able to pay. So the focus, I think, has been in disputes on the more practical consequences of COVID economically, both in connection with employers and contractors. And I think that projects that perhaps parties would have soldiered on with in better times, they've looked very long and hard about whether these are projects that they should be continuing with, and then have looked legally as to how perhaps they might be able to remove themselves from it. So I think that's an aspect that I'd not really anticipated at the beginning of all of this, but 1 year on, it is the more prevalent trend that I would say we've been seeing.
Thank you very much for that. Second question I was going to put across to you. I mean, you've talked about it in the sense that, it's more of the practical side rather than on the big issue, force majeure. And people are actually asking the fundamental question, should this project continue or not continue? And does the client want to pursue, or even the contractor? I suspect, in the issue of the composition of the dispute, even though the original agenda was very much in the force majeure area, are you saying that the composition of dispute has changed from normal dispute that you get on project? And if that has been any particular area that is quite prevalent that you see again and again, geography-wise or country-wise?
Yes, I mean, I think possibly the emphasis, we always, disputes bottom line generally are about money. Of course, claims have continued, financial claims, but perhaps the source of these have changed, or the emphasis. There will, of course, continue to be extension of time claims, additional cost claims arising from cost overruns. But as I said in my introduction, because we're looking at projects that are perhaps being terminated, the nature of these sort of claims has perhaps come more to the fore than pre-COVID. I don't think I would say that there's any particular regional trend. My sense is that that's pretty much across the board. What I think has been interesting is that parties have continued to advance their disputes, even although they've not had an opportunity to do these in person. And perhaps I had anticipated that there might have been a bit of a lull in that. But I think quite early on, when people realized that we were in for the long haul, they have adjusted the way that they manage things. And that's really why we're doing everything quite comfortably online.
Well, it's interesting because that particular statement you make about online is one that I was going to lead on to, and perhaps this is not in our original brief, but I will throw it at you because I think you led me into that. Do you think the industry has responded well in resolving issues using this digital platform? Because now we are, as Bill said, we've touched base to nearly 20,000 people all over the world, which FIDIC never used to be able to do that through even some of our conferences. And I was talking to Sir Vivian Ramsey the other day, and he said, I'm doing hearing all the time. Do you think the industry has responded positively to the idea of now remote working, remote hearing? And has that helped in resolving dispute quicker, or has it been a hindrance?
Yeah, I think the industry has responded amazingly well. And I know that the construction industry historically has sometimes been criticized for not being fast and taking off regarding technology. But as far as dealing with these things online is concerned, it has, in my view, been so impressive. It has given opportunities to parties because historically, for example, in an arbitration, you could potentially have 3 arbitrators traveling with the traveling costs and the traveling time for hearings. All of that is gone. Now, of course, there will be a desire to return to some in-person hearings, and I think we all want that. But my view is that it's likely going forward that, for example, one-day ones and things like that will be more likely to be dealt with remotely because they're much more cost-effective. And there is also the issue about availability of a tribunal, because you're much more available if you're not adding on traveling time one way or the other. So I think things probably have been dealt with faster. We've scheduled hearings more quickly. One of the, well, a couple of downsides, I would say, but all perfectly manageable, is that, as we all know, concentration span online is not as it is in person, and you need to recognize that when you schedule your hearing. And the other thing, and this is possibly a personal plea as a tribunal member, is that the temptation is that we get thrown electronic documents that would go on forever. The size of them is enormous, and there has perhaps been an increasing tendency, as everyone has embraced that, to perhaps overload the tribunal with information, some of which might not necessarily be relevant, but that's maybe a personal hobby horse of mine. But it has given rise, I think, to an opportunity for parties who might not otherwise have felt able to afford to deal with disputes this way to do it, because it is cheaper and more cost effective.
Well, thank you very much for that. I thought you were going to say that because I can feel it in me. I'm sitting where I am, and don't ask me where exactly. And in 1 hour, I can be in India. In the other 2 hours, I can be in America. 1 minute, I'm in Asia. And is that efficiency? I think to some extent that yes, the industry has responded. Thanks very much, Lindy. I'll come back to you. I'm going to invite Mohamed Ali Janah, my good friend, where FIDIC signed an agreement with the organization that you represent not too long ago. Mohamed, would you kindly introduce yourself and your organization, and then we'll give the kickstart.
Thank you very much, my brother, for inviting me to this session. Bill and Nelson had been very kind to have me here today with other speakers. I today represent the International Federation of Asian and Western Pacific Contractors Associations, as its current president. We have 19 countries in the Asia Pacific and Oceania region. In fact, late last year we signed a relationship agreement with FIDIC, and I have been a contractor all my life, all my working life, and currently I also represent the Maldives Contractors Federation as its president, and also the National Federation of Employers. I think that would be enough for now.
Okay. Thank you very much,
I'm ready for
Madam.
your questions now.
Yes, I'm really delighted you're able to join us. We were getting worried earlier on maybe the weather is just too good in Maldives and we're not going to have your pleasure. So I'm really pleased that you're able to join us. Not only do we build on the relationship that we've started with FIDIC not too long ago. The question I was going to put across to you, Mohamed, is really what are the biggest issues for contractors that are likely to cause dispute? I mean, Lindy talked about it's not the area that she expected, you know. I mean, can you relate to that? What are the key typical area that, you know, during this COVID that the contractors are really concerned about that may cause dispute from your experience? Back to you.
All right, thank you very much. Very good question. In our part of the world, which is, you know, having the biggest development projects in the Asia Pacific, as you know, I will divide my response into two parts. All right. So under normal circumstances, the biggest issue the contractors in this part of the world face are that they do not read the contracts properly. I would say that. Okay. And out of the 19 member states, 15 member states of our organization follow FIDIC contracts. But even if they follow the contracts, the engineers on the ground, most of them do not speak the English language in our part of the world. And this is a serious problem, be it FIDIC or other forms. The communication gap that we have between the owners and the management is also a major issue. So the legal department of the companies, when they come to, you know, analyze these contracts, getting it filtered down to the site people, that leads to, you know, certain issues, you know, and when it comes up to dispute resolution. So also in our part of the world, you know, some of the countries, they change the allocation of risks in the standard form of contract. So for example, the red book is modified to an yellow book. You know, this I think I mentioned this to you when I met you in Manila, you know, earlier on before COVID, right? So organizations like JICA call it a one-sided contract, you know. So that's an issue. So I believe we have been speaking about what could we do about this, you know. So the remedy for this is only training and follow the golden principles, as you know. So but when we speak about this, I would, I mean, with your permission, I would say that some of these training programs are very expensive for contractors in this part of the world. So I think this is an issue we need to address, and I think with our, you know, association, affordable training to a major part of the Asia Pacific region is required, and I think this is something we could work on together. And when it comes to the COVID, you know, pandemic situation and what is happening right now, I think it has really brought a positive aspect on the subject that we are speaking today. Actually, the employer relationship and the contractor-employee relationship has really improved in this situation. I've been doing surveys across our members, and with regards to the extension of time, the costs incurred due to the COVID situation, and also the future costs, you know, I think we are a new dialogue has opened up. So the lesson that we are learning through this is that um, uh, we are not saying that this is a force majeure, or, you know, but it is a situation where we have to talk, and we in the future we have to see that we avoid the issue of disputes. So instead of dispute, the dispute mindset, the mindset that we want to bring to our part of the world is how could we avoid disputes. I think that's all I would like to say for now.
So it's really about dispute avoidance now. But what I also hear from you, Mohamed, is that the culture is changing. That this pandemic has actually opened up a better dialogue between contractor and client, and there is more amenable approach because everybody knows that somehow we have an end goal, which is for both parties to achieve their objective, and it's about finding that amicable way to do that. But do you feel that that there's a change in attitude, that we're not going, contractors are not going for, there's a claim, it's about how do we discuss and resolve it? And do you see that happening on site with your members across the region that you are covered?
Yes, the lesson we are learning is that, the willingness. So pre-COVID, I think it was very harsh on the contractors, and the contractors always felt that, they are being, unreasonably, treated by the clients. And as I would call it, we felt that it was one-sided. But then, after the pandemic, everyone wanted to progress. Everyone wanted the end results to be good, and to make the end result, successful. We all came to the conclusion that without helping each other, we cannot, achieve our goals. So I think, and to achieve those goals, we have to understand the issues that we are facing together. So I think it has become a common denominator, like where do we sit and resolve the problems. So when we try to, pinpoint and address, we found out that it is the understanding of the agreement that we have between both the parties are not understood to each other well. So I think the demand for the training in this part of the world, the importance of FIDIC has become very important under these circumstances. So I think we have a lot of work to do together.
Okay, Mohammed, you are absolutely straight on with your echo message that there is a big capacity issue, which I think is what you're trying to tell me, and that language communication is a big issue. And yes, contractor always fall into the foul of sign the contract, chuck it away, don't read it, and then when something come up, you say, oh. But actually, what I enjoy most about what you said is not only there is a capacity issue, which we need to work together on, is that there is a mutual respect between the contractor and the client, that we have a common goal. And the common goal really is to deliver what the product is, because it's when we deliver that we can both, actually celebrate that we collectively we work on that. So I'll come back to you on that. Thank you very much on that. So I'm going to go to Rebecca now, which is actually quite interesting. Rebecca told me earlier on that it's nothing to do with Brexit, but she spent a lot of her time in London and she's now relocated to France. And I'm not going to ask any more questions. So Rebecca, it's your floor for you to introduce yourself, and then we can kickstart. Rebecca?
Thank you very much, Nelson. So I'm Rebecca Shulter. I'm a partner at White&Case, which is an international law firm. I am in the international arbitration team, but I specialize in resolving disputes on construction projects, and I have done for my entire career. And as Nelson has said, I spent most of that career in London, and I very recently relocated to Paris. And I'm happy to answer questions, but no questions relating to Brexit. Thank you.
I will keep away from that. Well, put it this way, Rebecca and I share quite a lot of things in common. I spent my early formative year in UK, and the last 2.5 years I'm in France, or should I say I'm in Geneva. And while your French is much better than mine, I would dare not compete with you along that. And I will not ask you any question to do with Brexit or anything of that nature. My question to you, Rebecca, is what kind of contractual measure would you help, to reduce disputes, looking at it from the standard point of where we are? We've had Lindy talking about, it isn't what we were expecting. It's more of a practical issue. We have Mohammed saying actually the relationship is getting better because everybody wants to aim through the goal. And from your point of view, what are the contractual measures you think that we should be introducing to help us to avoid dispute? I suspect if you're in the business of dispute resolution, one of the jobs is to actually avoid it and actually make it like much easier. What are your comments on those issues?
Thank you. So some of these points probably shouldn't sound controversial to people, but you'd be surprised how often they come up as a matter of disagreement on the cases that we work on. I think the most important recommendation I would have to begin with is to make sure that you have a really clear dispute resolution clause in your contract. Of course, if you've not amended your standard form FIDIC contract, this won't be a problem. But, just in the last couple of years, I've had cases where the contract has more than one arbitration agreement, and they have conflicting provisions about the seat and the number of arbitrators. I've also had cases that have both an arbitration agreement and then a clause stating that the courts of that country have the exclusive jurisdiction for disputes. And I think this can happen in construction projects, particularly because of the way we put our contracts together. You will have your technical specifications, your general, your particular conditions, a letter of engagement, and it's very easy for people to just add something extra to the last document that gets agreed without checking how it works with everything else that you have in the contract. So that is a basic point, but a really, really important one, I think. The second thing I'd say is that I'm a big fan of tiered dispute resolution clauses. I'm not just saying this to suck up to FIDIC. They're popular in lots of standard forms used on construction and engineering projects. And I think for good reason, because they allow the parties to really concentrate on resolving disputes incrementally in a way where you may be able to get a swift resolution or even just a temporary resolution. And then you can concentrate on finishing the project, but still you reserve your right to go to court or to go to arbitration later if you're unhappy with the outcome. The third thing I'd say is this is not so much a contractual measure, but it's actually putting the contract that you have into action. The number of times I've seen somebody sign a FIDIC clause, a FIDIC contract, which provides for a dispute board, and then they don't actually appoint a dispute board. It's quite shocking, I suppose. And my view is slightly prejudiced because I only see the projects that have gone wrong, remember. But it happens more often than you'd care to believe. And the problem is once parties have got to a stage where there's a disagreement, trying to reach an agreement on something that should be quite straightforward, like the identity of your dispute board or the number of arbitrators that you should have if you have two clauses, they become very difficult to do. And once parties have started spending money on lawyers to argue about how they will spend more money on lawyers later, it just makes the gap between the parties much larger and they become more entrenched in their positions. My colleague here at White&Case, Chris Sepala, who I know is known to many of you, he likes to refer to dispute boards as akin to insurance policies. You pay the premium. You hope you don't have to refer to it, but it's there if you need it. And you should be making the investment setting one up on the same basis.
It's interesting, Rebecca, you used the word there. Chris Sapala says that dispute board should be an insurance policy. You hope you don't have to call on it, but if you do call on it, because you pay the premium, you actually get coverage on that. And the 3-point you rate is actually quite fundamental because what you're saying is that you have a claim clause in there or dispute clause. You respect it, you play it, but actually the tiering of the process, which you have different level to go through. And now that under the FIDIC 2017, we're now talking about the DAAB, which is there's an avoidance element that comes into it before you go into the resolution. And that's actually quite interesting. The question I was going to put across to you, I think you spoke eloquently about those 3 points, and I take them on board, was that how can the legal profession help the contractors and the consultant and the client? I mean, I know that whichever way the legal profession and the court, the client needs you to help us to, put the document together. The contractor needs it in interpretation. If I go by what Mohammed is saying, was that some people get a contract, don't read it. They need interpretation of it. And even the consultant that need to put it together needs some understanding of where the technical specification and issue of liability. How can the legal profession help the 3-party bearing in mind that, you may be at the front end and the back end, what support can you give? I'm asking the obvious question.
We try not to be at the front end and the back end, because if we've ended up with a dispute, then the advice at the beginning maybe wasn't good enough. But in addition to the points that we've already discussed about the importance of setting your contract out, I think that early advice sometimes is invaluable, in the same way that people like to sign contracts and then, as you say, put them in the drawer and only get them out later. Some people have a phobia of dealing with lawyers. I don't take that personally, but I know that a lot of the work that we do is actually in the background when projects have started to become a bit destabilized and there are problems. And one thing we can do is provide early input if there's a disagreement on an interpretation of a key clause in a contract, to try and stop those kinds of disagreements snowballing into a much larger problem between the parties. Training is another important part of that. We've already discussed. I won't repeat those points, but I definitely agree with them. The other bit of advice that I think, if I had £1 for every time I said this, I'd be a millionaire by now, is record keeping. A lot of what we saw last year was when the pandemic, when everyone realized how awful it was, everyone immediately issued a force majeure notice. But what comes afterwards? If you're saying, I can't get materials to site, I can't get labor to site, where are you recording that? Show me the impact on the program, keep the records for the sites. And these might sound like points that lawyers are making from a lawyer's point of view, but they actually serve a really practical purpose, because if you're a contractor that wants to make a claim, you want the employer to have a collaborative relationship with you, you need to show them what the impact is so that you can work through that together. And if that's not possible, and you have to talk to your engineer, maybe you have to refer it to a dispute board, that dispute board or an arbitrator later, they also have to work through what happened to come to a decision on it. And if you don't have those contemporaneous records, it becomes very difficult for people. So, I think it's definitely a resource that's worth, investing in, not with an eye on the dispute, but with an eye to avoiding the dispute.
Thanks very much, Rebecca. Considering I spent 14 years of my life with a company called High Point Rendo, who specializes in nothing but claim or dispute, I know the importance of record and discovery. So thank you very much. I'm going to come back to that later on. I'm going to introduce Jim, or James, or Jim Perry, whichever is the right one. I call him Jim. Jim is a very good friend and also well known in the dispute world. James, would you introduce yourself? And then I've got a couple of questions so that we can get started on. James?
Good morning, everybody, and thank you, Nelson, and thank you, Bill. It's a pleasure to be with you again. I'm another attorney, I'm afraid. I'm based in Paris. I have been here for the better part of the last 33 years, but I'm a U.S. attorney, Washington, D.C. bar. I'm a trained civil engineer, also with degrees from the U.S., but grew up in the U.K., in Scotland, actually. And my practice is international arbitration, dispute board member, and mediation, working just about everywhere from Latin America through Southeast Asia and Africa.
Thanks very much, Jim. I think a lot of us know your footprint all over the world. I suspect one of the things that Lindy talked about is that you must be missing all those air miles and traveling, and you have to do everything by Zoom by now. So let me start with the first question to you, James. Once the dispute process is started, what would you be your advice to parties as to how to approach the dispute, and what have you seen work well and what does not work so well?
Well, I think the first thing I would say to that, Nelson, is I think we need to be a little careful about the shoot first, ask questions later approach. There is an awful lot of benefit at the moment to work through these problems with the engineer and with the dispute board, if you have one in place. And when you say a dispute, I'm assuming that we have a dispute board and we're going to be disputing at that level. If you filed a formal referral, and you may have problems, as Rebecca was talking about, if you've not appointed your dispute board, you're going to have to put one in place. And unfortunately, when we have to move quickly, that can be time consuming. However, when you put the dispute board in place, I do highly recommend that you think about using them for dispute avoidance first rather than actually going straight for the dispute. And there's good reason for that. Once you've filed the referral, you're setting yourself on a track for a dispute board decision. And then that decision is going to be theoretically the end of the dispute board's involvement with that. And if you're disputing on COVID issues, that's maybe a shame because I think the dispute board's involvement over this long period, it's been 15 months, would be much better to have the dispute board helping you with informal assistance to try to deal with all of this. So if you have the intention, though, to file a dispute, I would recommend using the dispute board in a targeted way, trying to ask specific questions about entitlement rather than trying to overload them with all the issues. Use the opportunity of working with the dispute board to understand your case, develop it, understand the strengths and weaknesses of your case. Work with firms like Rebecca's to help you because we're learning nooks and crannies of the FIDIC contract we don't usually go to. We're spending a lot of time on the health and safety provision of 6.7 and 8.5 on delay by authorities and 8.4D on epidemics. And we're certainly spending a lot of time on 13.7 changes in laws and reading a myriad of decrees and regulations coming from different governments in different places. So getting to grips with this is very important. And I recommend this in any situation, but do not stop trying to settle your claim just because you got a formal referral. Parties should keep trying to discuss with each other. They should be spending time trying to solve the problem in parallel. The DB process, the DAAB process can help you learn about your case and help you come to a better settlement. And as Mohamed said earlier, we don't know our contracts well enough. And I come back to saying, please try to avoid the shoot now, ask questions later. There's a lot of questions, and the DB can really be helping you work your way through these questions. Put people at ease. We're panicked. This is going to involve time, often money. And people are concerned about their budgets. Terminations are happening. We all need to use the DB plan. We will save the projects and we'll get them back on track. Going to dispute too early is a mistake.
Well, good point raised here there, Jim. I think the point you raised was about, using the DAB as DAAB. And I suspect if I go back to the point that Rebecca said, is considered to be insurance policy. The earlier you get people involved to give you expert advice on it, the much easier it is for people to actually resolve the issue without going to full length. I suspect the challenge that a lot of people say is that some people see it as, why do you have to retain, your DAB? Because I think under the 1999, you have a choice, but in the 2017 effectively say you have a standing DAB. And I think the challenge you have is really, people say, well, that's additional cost. But I think Rebecca is saying it's a good insurance policy because in most cases you can pick up those issues and resolve them before they become a real dispute by keeping them on. So the question I was going to put across to you, Jim, is, has the COVID really extended the length of dispute, or do you feel that, what Lindy was saying earlier on is right? And also Mohamed saying people are now trying to get and work together in a collaborative manner. Do you see from your experience that, things are getting extended? And if it is extended, is that, how can we avoid that? Or do you think everybody is really trying to find a solution and dispute is more amenable? James?
Well, I think we are suffering from not having enough standing dispute boards in place because I think we aren't getting enough collaboration. You'd like to think that in something like this, people would get together and work together more. And I think they can if they have a coach. And that's where a dispute board can come in and really help. Are the disputes getting longer? Well, we've had a 15-month ongoing event now, so by definition we're in a long dispute, and we're also dealing with a lot of different issues at several stages, and maybe moving back in and out of stages. We have work stoppages that shut the site down for a period of time because of a government decree or because we want to test everybody. We have a massive site and the only way to test 4,000 workers is shut the site. We then go back to work and we have social distancing and health and safety measures that mean you have to put on more work buses, you have to increase your living camp, there's loss of productivity, those measures have direct costs. That's a second stage, and you may roll back into the lockdown stage. And then we're having a third element for international contractors. They're suffering different changes of laws that don't really entitle them to claims under FIDIC in their own home countries, and they're probably not force majeure either. So we're dealing with all these different levels of claims at different times. So it's a long process, and again, this is why I come back to the view that going straight to dispute and filing a referral is not the best, because we are in a situation where we may still have months to go here. And you really can benefit from that dispute board continually being there to help you, rather than having them come in and out 84 days, give their decision, and finding that when you want to come back to these same issues, perhaps because you've not done the research on them and understood your contractual and legal rights correctly, the dispute board has to respond, I'm sorry, but it's res judicata, we're finished with this, we can't come back to this issue anymore. So I'd like to take the opportunity to pass the message today to keep the dispute board involved, use these platforms, use the Zoom platforms, don't use the COVID as a reason not to have a dispute board discussion. We are getting much better at using these Zoom meetings and being able to help. For informal assistance, I find that the Zoom is harder than in person. It's not quite the same as being with people, but it's a great tool. We're lucky that the timing of technology was coincidental with what we're facing.
Okay, thanks very much, Jim. From that, I'm going to come back to Lindy now. Lindy, last time we talked about it, I think you raised the issue about the volume of data that now is being cascaded, to be reviewed during the process of dispute being resolved. The question I was going to put across to you, I mean, has there been any shift towards, do you think because we're now, we don't have to travel, we have the data available to us, and people can now more program their issue, do you think we're able to resolve dispute quickly and hence reduce the cost of litigation? Ultimately, of course, I mean, the point that Rebecca talked about, looking at the tiering of the dispute process. Do you feel now, Lindsay, that things have been able to resolve and we are avoiding unnecessary litigation costs, or is it too early to make that sort of judgment?
I think the signs are yes. The mediators that I know have never been busier. Okay. So for me, that is a sign that people are opting for what you might call a non-confrontational method of resolution more readily. I think there was a view at the beginning that mediation would be very hard to do remotely because it is such the dynamics of discussions, that sort of thing, everyone thought you need to be in person, but that has not proved to be the case. I think it does demonstrate parties' willingness to try to resolve things. So I think the answer is yes. The other point that I think has been made is, and Jim made this point a few moments ago, if you start arbitration or some formal method of dispute resolution, it does not mean that you should give up on trying to resolve it separately. And I do have 2 or 3 arbitrations at the moment that are on hold while parties are in discussions. So running parallel mechanisms for resolution of disputes has perhaps also increased. And again, that may be another function of COVID and the way that people have approached these things.
That's very helpful. But when you say running parallel, do you think people are fully aware that these options are there? Because if I read it correctly, in my limited experience, and I stopped being a practitioner now for quite a while, is that people have this dogmatic issue that you trigger, the dispute resolution clause, and that's it. And in fact, you find that while that process is going through, there's a number of options you can use to resolve it. And if I start from the negotiation, adjudication, mediation, and the dispute board, and you go on, these are tiers of options you can look at. It seems to me that quite a lot of people, and maybe they're just naive, they think once you trigger one point, that's the only way. And what I hear from Jim earlier on is that, no, use the other mechanics that is available to you. Do you think people actually understand that? Or is there a lesson to be, is that part of the training that Mohammed was talking about earlier, that people need to understand the various means of actually addressing the issue?
Yes, I think that's such a good point. I think it is part of the training, because there is probably a general perception out there that once you have pressed the button on one thing, you have lost the opportunity to do others. And just taking dispute boards as an example, in my view, there should be absolutely nothing to prevent a dispute board continuing to operate and deal with issues, even if one discrete issue has gone off to arbitration. And similarly, if parties are in arbitration and they decide that they wish to mediate one aspect of it or refer it back to a dispute board or whatever, all of these things are possible. But I agree with you entirely that that is not always something that's readily understood by people.
Thank you very much. I'm going to come back to you, Mohammed. One of the questions I was going to put across you is, well, looking across your region of coverage, and you did talk about 15 out of so many, very, very versatile with FIDIC contract. The question I was going to talk about is, what difficulties, if any, do Asian region face when working on European or American projects? Do they actually have difficulties in working on projects being funded or financed by, West? Or is it a case that it doesn't really matter, it's business as usual? Mohammed, what's your take?
In our part of the world, as you know, the situation right now is it's like members have got these contracts coming from different organizations, like the multilateral development banks and development organizations, government contracts. So and most of the countries have got these issues addressed in this part of the world in arbitration centers like Singapore and Hong Kong. But the other member countries, they are practicing the 15 member countries that they are practicing the FIDIC contract. They are not having the dispute resolution mechanisms to the extent that is required. So I think that is where the difficulty is, and that is where the training needs are coming. That is where we need to look at our cooperation and coordination. So in some countries in our part of the world, if we have a dispute, and then if we pass the arbitration and then go to the court system, it takes decades to resolve a problem. So as I said earlier, we are trying to avoid that situation. And to avoid that situation, we need to understand better how we could address this. And most of the countries in the region are opting to have a clause in the agreement where we choose Singapore as the arbitration center, or Hong Kong as the arbitration center, and sometimes the UK is also the arbitration center. So I think this is where we are right now, and we have really important requirement to give the training to our member states, member countries, to be more aware of what we are signing and what we are engaging in a contract itself.
Well, Mohammed, I wasn't gonna come back to you, but you're really strong on the issue of training, and I can understand the frustration. I mean, how do you foresee that can be addressed? Because we've talked about, Lindsay was saying earlier on, a lot of people didn't understand that you can have the dual parallel approach. And dual parallel approach means that, okay, you got the big juggernaut, but you can actually have a side conversation on a number of options to resolve a number of matters. And if training is what is needed, in your mind, should the training be provided by, the like of your association in collaboration with FIDIC, or is it something that you see that is a capacity issue that the banks who are financing this project will condition that as a precondition of the project? How do you think we can actually, resolve that issue?
So I think it has to be a collective effort.
Okay.
And, we currently have the Asian Development Bank in
Yeah.
our part of the world. We have the Asian Infrastructure Bank right now,
AIB.
the AIB.
Mhm.
And, our headquarters, although I'm in the Maldives as its current president, our headquarters is in Manila in the Philippines, as you know.
Mhm.
And you have some very good people in Manila, like Castro, our friend, right?
Yes.
So he's been advising me and helping me on many fronts as well. So I think there are good people in the region, in our region, as well as many speakers here are very good people, whom we can all have a collective effort and look at our region separately. I think FIDIC and the Asia Pacific region, I think there had been some neglect, I would say, when it comes to when I speak from the contractor side, because it's only in 2020 that we signed an understanding, right? So I think there is work that we could do together, and an affordable training system, if we could establish, I think it's going to help. And it's very sad that due to corruption and other issues, when it goes beyond a dispute resolution situation, when it goes to courts, in many of our countries, the cases go on for 10, 20 years, and everyone goes bankrupt. So we want to see that we avoid these kind of situations. I hope that explains. That's some kind of
It does, Mohammed. Thank you very much. Point taking. We've got about 4 minutes before I go and pick up question from the floor, but I have a couple of questions, one to Rebecca, one to Jim, to try and close out. Rebecca, I mean, you've had all the comment being said about, we should try and avoid, going for the juggernaut. The question I was going to say to you, really, I know you did said earlier on that you either get the front end or the back end, you try not to do both. The question, at what stage in a project are most disputes raised from your experience? Did you find that this happened from the whole of the project life cycle, or sometimes is it very much at the inception stage of it, or the midway, or does it tend to be when the final account is coming up? Is that when your experience show we get more dispute on coming through towards the end? What is your take?
Yeah, so in my experience, I mean, most of the cases that I deal with where things have become contentious, you're getting towards the end of a project, or sometimes it's even after a project. If you have a case with a defect, that won't become apparent until you're nearing practical completion, or sometimes, after practical completion when things aren't working the way that they're supposed to. And I think that's just because maybe the claims for the extensions of time don't go in until you're getting closer to the completion date. You might have some disputed variations, but they're not becoming, very serious as problems until you get to a later stage and people rightly have their minds on the project. I think what's most concerning is when you see things going wrong at the very beginning of projects, because if things begin to go off the rails at the very beginning, then it can be very, very hard to bring them back to successful completion.
So your comment is that, within the whole of the project life cycle, when you start to see the warning light at the beginning of it, that's when you need to nip it in the bud. Because if you don't do it at that point, it becomes a balloon issue at the later end. Is that a fair comment?
Exactly. If you have a problem that's not resolved at the beginning, you're going to get a delayed project. You may even end up with a terminated project because, if the impasse becomes too big and there's no progress on the actual project, then it's difficult to overcome.
And do you find that, sorry if I can extend that question because I'm getting excited about that issue. Did you find that, because one of the questions I put across to you, Rebecca, earlier was, we are all in it together. The client wants a project to be completed. The designer and the engineers want it to be, that project I can put on my profile that I'm the one that delivering. The contractor wants to show the photograph, and somehow you guys are in between advising all various parties. The issue I have in my mind is that should it be a checklist that your client can come to you at the beginning of the project, say, look, we've advised you the front end of this project. Here are the checklists that you should have in the different phases of your project to make sure that project ultimately turn out to be what it is. Do you find that contractor or consultant or client ask you to give them, that's the risk management issue, or it's just a straight vanilla, there's a dispute and help? Did you find that? Does that often come across?
I mean, I would love to do more of that kind of work. I would love clients to come to me earlier and say, is everything on track here? Unfortunately, not everyone wants to spend money on lawyers. They want to, concentrate on the project. Interestingly, where we do that kind of work more often is if we have been working with the funders on projects.
Okay.
And they want, they get updates from the engineer or their own consultants, and they just want a third party to give them a view on whether this looks normal or not.
That's very good. Thank you very much. So the advisory side of it is something that any party should be looking into. Don't wait until things just fall apart. So can I come back to you, Jim, for my last question before we pick up a question from the floor? Because Andy's telling me there's a lot of questions coming through from the floor. I mean, this would becoming more or less complex. Do you feel? I mean, in the comment that Lindy said, he said it becoming a practical issue. Do you, in your experience, feel that dispute is becoming more or less complex? With the integration with framework, alliancing, and all the sort of working practices that goes through, or it doesn't really matter? What's your take, Jim?
Well, I think alliance format of contracting isn't something that I see that much in international infrastructure projects at the moment. However, if we strip down alliancing and go to its DNA, so to speak, what is it all about? It's about trying to create a spirit of cooperation, transparency, and openness, and a willingness to compromise. Those are all important elements that are already in FIDIC contracts, especially if you're using a dispute board. And it really, in my view, does boil down to the individuals often, and if there is a dispute board, again, how well the dispute board can bring that out in the parties. I think if you have parties that are willing to work this way, the contract language is not unimportant, but it's a secondary factor. You can have alliancing language in your contract, but if the parties aren't willing to play by the rules of alliancing, then you're still going to have disputes. And maybe arguably the language is a little too loose in some alliancing contracts, so you actually don't have a proper framework to solve those disputes. But if you have those elements that you're able to get the parties to a space where they are working openly and transparently, then I think disputes can be less complicated, much less complicated. If you're using non-binding opinions from dispute boards, that can come very quickly. That saves time. If people accept that, then they move forward. And to your point earlier, Nelson, the statistics do tend to show that dispute boards, their presence actually saves more time percentage-wise than money. So that's where they can really be useful, and that is important to make the disputes less complex. So I'm optimistic from that standpoint. I'm also optimistic that I find younger people are much more open to working this way. They've maybe been used to doing it. 33 years ago, we didn't even think about having mediation or dispute boards. So it's a good step with the younger generation. The downside, unfortunately, I do have to confess that I'm seeing a danger that once a referral is filed, there's a tendency to treat it like a mini arbitration. It can become a speed bump on the way to bigger litigation, and it can become almost full-blown arbitration in the first place. That's a real danger. We need to be encouraging more people from the profession, more engineers at a certain point in their career to take the training so that they can become leaders and mediators and dispute board members. And we need more, I think, professionals like Rebecca and Lindy and others who understand the benefit of these ADR process and help their clients and encourage their clients to engage in it and take advantage of the dispute board as a way to simplify, not complicate things.
Right. Thanks very much, Jim. I'm not going to start taking questions from the floor. There's a lot of questions that is filtering through. Some of them, believe it or not, are very simple for practitioners. You probably get to know them. And some of them may probably become complex one. For me, as a qualified adjudicator, mediator, and arbitrator, I understand the difference. But there's a simple question, and I think this is perhaps direct to Lindsay, was how do mediation and arbitration differ? And this is Shashi from Mauritius. If in case does not settle at the first mediation session, what's the next step? I think I have an answer to this, but I think Lindy, since the question, we put that across to you. What's your take?
Okay, thank you, Nelson. The answer to the first part of the question about how are they different is that mediation is a jointly a solution that is worked on together by the parties, and the mediator assists parties to do it. Arbitration or litigation, of course, is when you entrust it into the hands of a third party or more than one third party to determine the dispute. As far as next steps are concerned post-mediation, it depends, first of all, on what your contract says, because as Rebecca had mentioned, there are many contracts which have what we call a tiered dispute resolution process that talk about mediation being one of the steps. Sometimes it's discussion between senior executives and so on, until you get to almost what we would call the ultimate, the end game, if nothing else works, which would be arbitration or litigation. If your contract says nothing about what happens post-mediation, it will typically be either arbitration or litigation to resolve the dispute.
Thanks very much. I think I have the answer. You've just reconfirmed my view. And if you happen to be in UK, whether your contract says or not, there's an adjudication by law which is standing in place. The same chap from Mauritius obviously is following Mohammed, then turn around, I think he's echoing Mohammed's comment, which is, what's it being done by FIDIC to make more FIDIC trainer inclusive? Most of the trainers are from EU, and we don't even have a trainer certified from India or from different angle. I have news for you. And I think, this is Mohammed will be very happy to hear this news. I have news for you. FIDIC is now creating what they call FIDIC Credentialing. It's not a sales pitch at all. It's FIDIC Credentialing Limited. And I'm delighted that Lindsay sits on one of our, committee there, is really to increase number of qualified people as an adjudicator that can be in the DAAB, or to train people who really want to be what I call trainer that can train other people. Also, we are creating a product which we call the FIDIC Certified Contract Manager. Again, that should help a lot of contractors. Opportunity that's coming through. Yes, the answer is yes. For legacy purpose, this is where we are. But trust me, Mohammed and I know, and Bill and I know, that one of our push is to make sure we can increase the bandwidth of people who can provide this training, who have knowledge and who are qualified as adjudicators. So if you are interested in that, I would suggest to you, please be on the lookout and see what FIDIC is doing. There is opportunity there. And actually, I will go to the extent that we are looking to collaborate. This is why we signed an agreement with Mohammed's organization. At a point, if it wasn't because of the COVID, is for us to be able to develop with them what it is that they need and see how best we can deliver that with local people so that we don't send people around the world. I think we all learn now from the COVID-19, there's a better way of doing things. You can do it online, you can do it physical, you can use local people. So rest assured, we're working on that and we'll come back to you on that. So there's a question that is also from, I'll pick another question here, which I think if I've got it right, is directed towards, his name is Andrew Dixon. So do you think faster adoption of collaborative contract is possible? And what needs to happen to be kickstart this in the international market? Now, I know that Jim talked about the essence of the contract is collaborative, is about language. But Jim, in your mind, do you think, adoption of collaborative contract, would that help, to improve the situation, or is it very much a big multi-billion pound project that you think this is doable? What's your take?
I am a fan of the concept of these types of contracts. I think it is in the future for international work at some point in time. And I think in private situations, it already has a place, and we're already seeing it being used successfully on occasion. I think what makes it work so well in places where it is working now is that you are in mature markets, sophisticated markets, where employers are able to compromise. They have that liberty to compromise. The players are all working with the same background from their own legal systems. They are comfortable with the similar legal system or the same legal system, and they also have the same custom and usage practices. So they're playing by a set of rules that are homogenous and they all understand. When you go to the international market, the form of contract may be imposed by a development bank, so it wasn't chosen by the employer in the first place. And if you use a collaborative type of contract, then you may run into problems that the employer's agency doesn't really have that kind of liberty to work that way, and it creates some difficulties then. That to me is the largest obstacle of getting there. But to me, that's a question of evolution. Unfortunately, I don't think it's something we're going to see in the next 5 years. It's going to take longer.
Yeah, thanks very much, Jim. There's a question here. It wasn't directed to Rebecca, but I think, Rebecca, you are more than qualified to address this question, because you alluded to the point earlier on. I think what you said was that you should consider the DAB as an insurance policy. So the question has come through from Andrew D. Torre is, what argument would you use to demonstrate that the DAB is not just a cost, but provide added value? So what is your take on that, Rebecca?
Well, I think you just need to listen to Jim Perry, surely, as your proof of this. No, it's I think if you want some cold hard logic, you need to think about the practicalities of timing. You know, if you have a very large project and a dispute comes up in the middle of it, and you need it to be resolved to move forwards, you can get your DAB decision within a matter of weeks. If the only alternative is to not have a resolved situation, so no money's changing hands if there's no agreement to be reached, and then you have to go to court, 10 years later you might have an answer. That's the argument for investing in a DAB.
Thanks very much. There's a question here for Lindy, and it's from Kaja Hamed. I think, when is a dispute between the employer and his engineer and not with the other party, the contractor, should the dispute board consider? Is it a dispute between the parties or humbly rejected? So when do you actually apply that, Lindy?
It depends on the nature of the dispute. If it is in connection with determinations, etc., which the engineer has given under the contract, these are issues which will be dealt with by the dispute board in the dispute between the parties, between the employer and contractor. If there are other issues that the employer has that are personal between it and the engineer, that's something that needs to be dealt with separately.
Good. Well, as a wise word that came through, I thought I should share this with you. I'm sure you've seen it. It's from a person called Francis Adetola. I think he's from Nigeria, because I do recognize that name. And it's a wise word that the most important thing is for all parties to respect the contract conditions. Once this is done by all parties, a dispute is avoided. Once disputes arise, relationships suffer and the project also suffer. I suspect we all agree with that statement. Is that a fair comment? Seems like a fair comment. Yeah, I think I'm going to use that again and again. Next question that comes through is from VJ Natka. And he said, "Dear Dr. Nelson, it would certainly help if the internationally funded bank insists and fund the training part of the FIDIC training, or put it under training head, which is part of project over and above the physical delivery for capacity building. The training should be extended to the chosen contractor as well." So, Mohamed, you haven't planted that question. What's your reaction to that?
I think it's a very good advice. I think the multilateral development banks should have a program with FIDIC and the regional organizations like us in capacity building. I think that would make a difference in around the world, and especially in our part of the world. I think we should take this on board very positively and work on that basis. I am ready to go with this from our organization, and to write to the relevant multilateral banks.
Well, put it this way, I think, as you probably know, Mohammed, one of the things that FIDIC tried to do, a lot of people know FIDIC for contract, but there are other things that FIDIC also does about our policy issue, guide and standard practice and all those issues. And I don't want to be seen as an advocate of saying push it because FIDIC is doing it. But one of the things that I think the bank has done recently, which we need to recognize, and perhaps this is a way for going forward. We know 7 banks have now signed up to the 2017 document, including, I think, Asian Development Bank is yet to come upstream because they're still working on the pink book. But the rest of the bank, including Asian Infrastructure Investment Bank, they've signed up to that. And one of the things they did call us on is that they want the document in 5 international languages apart from English. Okay, 5. They want it in Chinese. They want it in actually French. They want it in Arabic. They also want it in, if I've got it, Spanish and Portuguese. Now, I can tell you that to me was a foundation for training and development, because if we can complete that task, then we move in the right direction. And I've got good news for you. We're nearly 80% there. We're nearly 80% there. So I hope that once we got the language right, and then people can actually use that for training. But in the case of the banks actually imposing, I think if I'm right, Jim can correct me, or maybe Lindsay can correct me, the bank are now taking the DAAB to a point where on a project where they believe there is a gender abuse issue, that they will contribute. I'm not absolutely sure about this, that they will contribute towards the client cost for the cost of the DAAB to make it as a standing DAAB. So I think we are making some progress in looking through that. Mohammed, you will get my support. If you were to write to all the banks who are funding projects in your region and say this should be part of the project finance as a capacity building, and FIDIC will do everything to work with the local people to make sure that they can deliver those training in a cost-effective manner. So I'm moving on to the next question.
Thank you very much.
Question, from I think it's Branch Green, if I got it right. It said, could parties halt a statutory adjudication or dispute board process so as to attempt to settle amicably, bearing in mind that both statutory adjudication and contractual dispute board require decision to be made within a set period? So Lindsay, do you want to pick that up, please?
Yes, the answer is yes, if both parties agree. I do this regularly with my dispute boards for the very same reason as we've discussed, where parties are in discussion following a referral. So we agree that the 84-day period will not apply, and we adjust it by agreeing a further date. You must have a further date agreed to avoid it falling into a black hole and disappearing. But the same applies also to statutory adjudication in the UK. If parties agree that a decision of the adjudicator will not be required until the expiry of, say, 3 months, to allow them to discuss or try to settle something, the adjudicator will confirm that. And similarly, a dispute board will agree to extend the period, provided that parties agree. But you must agree a revised end date, otherwise the whole thing falls away.
Right. Thank you very much, Lindsay, for that. There's a couple of questions now before I bring Bill in. Bill, so I'm giving you a sort of a quick, amber light, getting ready. I think one is an extension to the word of advice, and it says, on a lighter note, what is needed is to train the contracting parties to read, and the read was in bold, to read. And he said many times the reason for dispute is due to the fact that the contracting party do not read. And again, in bold, the contracting that they enter into sign. And I think this goes back into Rebecca's point is, you must make sure that you understand what you sign up to. You must understand the mechanics of the system. And I think he said, as long as there is mutual respect and care, and the dispute could be minimized within early addressing, which I think is quite interesting. Next question is coming through from, I think it's Joe Martin. I'm not quite sure if I've got it right. If I pronounce your name incorrectly, please forgive me. The question goes, what about this still widely held belief that there exists such a thing as a watertight contract? It is because of this that contracts become ever more detailed and longer, thereby aggravating the risk of contradictory clauses. So it's a long and windy, and I'm going to start with James. What's your take on that particular question?
Well, it's a good question, and I would say that I know a lot less now than I did 30 years ago, and I think that's maybe because I believed in watertight contracts when I was younger. I think that that's the whole point of being able to negotiate and settle your own disputes is to come to that understanding at some point in your experiences, and maybe arbitration will do it for you, maybe dispute board experiences, but at some point you realize that even the best of experts may disagree, excuse me, on terms of contract. Things that may appear very clear to you may not appear so clear to an outside expert who's asked to be neutral. It's very easy to become partisan as you live through these hard projects, and keeping an open mind is incredibly important.
So, Rebecca, is there anything like a watertight contract?
Well, if there was, I wouldn't be in my job, I don't think. I mean, I echo what James has said, actually. And the other thing to bear in mind is that it's not always what's in your contract, but what's not in your contract. I mean, the example that Lindy spoke about and you spoke about, Nelson, a statutory adjudication is a classic one. You know, you cannot have that in your contract, but if it's a qualifying contract in the UK, you have that available to you, whether you like it or not.
Lindy, anything like a watertight contract? The same question. I just thought it's a good one to finish off. Is there anything like watertight contract?
I would echo Rebecca, and I don't believe there is such a thing. And almost sadly, the more people try to get that watertight contract, the more likely you're going to have disputes, because you muck about the standard form conditions and clauses that have been worked on for years and years. So sometimes the longer that it is, the more likely it is that there will be disputes and it will be less watertight.
So, Mohamed, exactly the same question. Here's the FIDIC contract. That's the thickness of it. Then it becomes that thick. And the client is being told, this is watertight contract. And you, Mr. Contractor, is there anything called water contract?
I don't think we can have anything like that. I think the important thing is to understand, and as we said earlier, to read through it, right? And I think it is through understanding the whole contract that we can make it better for all of us. And I think that is where we can make it watertight, not adding further clauses. I guess it is a better understanding of what we are entering into. When we have that understanding, I think it will become watertight. That is how I look at it.
Thank you. At this point in time, Barbara is reminding me that we got to do 2 polls to try and pull things to a closure. So there's 2 polls that I'm going to put across to the audience. The first one is, do you believe that the COVID crisis has encouraged a more collaborative approach to resolving issues or going to dispute? Yes, no, or no change? I guess the impression is hopefully there should be a positive change based on what we've just heard. So believe it or not, do we have a feedback on that, Barbara? Or is the system still thinking about it? Yes, 67%. I'm sure that we understand that, you know, collaboration is perhaps the way to go forward. Next question that I also see, Barbara, next question, I get that. Has COVID proven the need for increased use of dispute avoidance mechanism such as DAB? It sounds like we're asking the obvious question. Yes or no? What is the view of the panelists and also the participant? What is the view? After all this conversation we have from these eminent speakers, what is your view? Yes or no different? Barbara, do you have an answer? Yes. Well, put it this way, I just want to finish up with this point before I bring Bill in. When we started, the view was that there is a challenge in the industry. And now after we listen to the speaker, I hear that we have opportunity to work in a collaborative manner. Once again, we have our committee, webinar, which continue to go through state of the world that's coming through. And this particular one is to do with COVID-19. And so for those who are following us, please, continue to follow what we do. At this point in time, I'm going to invite Bill to give us a closing word of what you've listened to, what are the pickup there, and what should FIDIC pick up from that. Bill, the floor is yours.
Thank you very much, Nelson, and thank you very much for the Q&A with 4 excellent presenters. As with many of these webinars, I could probably talk a long time about all the things we heard, but I did make note of a few things that I think the themes came through in these webinars. The first one is to try to cost effectively resolve as many potential dispute items as possible, as early as possible in the contracts. Some mentioned that if the worst happens and disputes end up in litigation in the courts, they could last 10 years or even longer. And I don't know that that's universal among all countries around the world, but it certainly is the case with many of the very difficult disputes that I've been involved in that ended up with the courts. It's not good for anyone to end up in that point. We also heard about the need to lower the cost of training, and we are well aware of that. We appreciate hearing it, and the FIDIC board and Secretariat and Nelson, via the FCL that Nelson mentioned, are absolutely committed to making the training more cost effective. But having said that, we also encourage the people that need the training to keep their eye on the big picture, because in the whole scheme of things, if you're in a dispute on a major project, the cost of having been trained is minimal compared to what you're dealing with. I also was very encouraged and absolutely agree with some of the comments that FIDIC contracts are already collaborative in nature. And if you really read the contracts, particularly the 2017 contracts, which are very long, but they are in many ways collaborative. They are very clear with the rules. They emphasize dispute avoidance. They balance risks, as we always try to do on all of our FIDIC contracts. And if the golden principles are followed, i.e. the contracts are not modified significantly, then they're already in many ways collaborative by nature. I think it was Rebecca or maybe Lindy, I forgot, one of you mentioned that if a project goes off the rails early, that's very, very, very bad, and I couldn't agree more. And unfortunately, many of the disputes that you get involved with early are unforeseen conditions, and that can really lead to a very long, lengthy, and bitter fight. And we all know there's no such thing as a watertight contract, but the length should not determine whether it's watertight or not. It's the balance of risk and the clearness of the rules that are more important. So thank you very much. That's sort of what I got out of the webinar, and I appreciate, again, the input from all the speakers.
Well, thank you very much, Bill, for that quick summary of it. I'm not quite sure if I can do any more justice on that, but let me just start with few takeaway for me. I hear loud and clear the word of advice that comes from the gentleman called Francis Adetola. Wise word. The most important thing is for all parties to respect the contract condition. Once this is done by all parties, a dispute is avoided. Once disputes arise, relationships suffer and the project suffer. It's important that we look at the end goal for the project. And if all parties are in good condition and good relationship, then it is a win-win for all parties. Unfortunately, that's not the way the world works. At this point in time, I'm inclined to start by saying massive thank you. Thank you to Rebecca for supporting us, from Lindy, from Mohamed, and also from Jim for all your contribution. I'm extremely grateful for your time and your contribution, extremely valuable. There's a lot of takeaway for me, and I'm sure that I'll be touching base with each and every one of you. I want to say thank you to our president, who continuously support me and support the rest of the FIDIC Secretariat in driving this agenda forward to make sure we are connected with the world, we are connected with our member association, we are connected with the industry, we are seen to add value in the process of what we do. I also want to say thank you very much to my team, who are doing the fantastic job. They makes me look pretty. I'm very good, but they are the ones who are doing all the job. Barbara behind the scene, Andy behind the scene, Chanel behind the scene, Nadia behind the scene, all of them are contributing to the whole process to make sure we don't have any hitch in the process. And in good timing, as much as we try to finish the project on time to quality. I want to finish up bang on 1:30. So on that note, I want to say massive thank you to all of you, wherever you are around the world, who've joined us in this particular discussion. I hope you've enjoyed it. I hope for those who missed it, will be able to go on the YouTube and follow it. And I will say one thing, wherever you are, keep safe and God bless you. Thank you very much.